just the title, the next slide, please, Leanne. So, like adults, young people aged 16 or 17 are presumed to have sufficient capacity to decide on their own medical treatment unless there's significant evidence to suggest otherwise. Now, parental responsibility, unless discharged, lasts until the child reaches the age of 18. However, its impact naturally diminishes as the child grows older and their own views and wishes become more important. So of course, if we think of a 5-year-old's decision making is very different from that of a 13-year-old. So just for a minute, just consider how you might feel about a 16-year-old's ability to make decisions, or that of a neighbour, niece or nephew. You know, how much do we really respect young people to make decisions? So the objectives today, then, it's an introduction. Okay, so it's in an introduction to the Mental Capacity Act within the context of young people. So we're going to look at how the MCA is applied to young people. We're going to be looking very briefly at where the Mental Capacity Act does not apply to the same group of people. We're looking at DOLs within the context of 16 and 17-year-olds, parental decision making, and obviously we'll have the questions and Q&A session at the end. Next slide, please, Leanne. So this is our reminder slide then. So just going to give you a very brief reminder of the Mental Capacity Act. Could I just ask there's a bit of interference, so just to have your microphones off, and maybe I'll go on camera because it might be off camera. It might be that my internet connection is playing up a little bit. So there will be times that we all struggle with making decisions, whether it's due to illness, fatigue, or simply feeling unsure. However, the Mental Capacity Act is intended really to address those more complex scenarios, and it's specifically created to support and safeguard individuals who are unable to make decisions due to a mental or cognitive impairment, such as an illness, disability, or maybe even the influence of substances such as drugs or alcohol. So the Mental Capacity Act applies to individuals aged 16 and above, and applies to all kinds of decisions regardless of their significance. For the purposes of today, I'll be using the term young person, and it will become clear why I'm doing that as we move through the presentation. So the Mental Capacity Act applies wherever there are doubts over the ability of a young person to make a particular decision at a particular time, and the young person has an impairment of or a disturbance in the functioning of the mind or brain. Now, for the purposes of this Act, a person lacks capacity in relation to a matter if at the material time they are unable to make a decision for themselves in relation to the matter because of an impairment or a disturbance in the functioning of the mind or brain. So being able to decide on some days or not others, well, that's fluctuated capacity, and it may be because of an illness or a condition which changes their capacity, such as a brain disorder, a psychological illness, a memory disorder, such as childhood dementia. So it's important to note that lacking capacity to make significant decisions doesn't necessarily mean a person cannot make any decisions for themselves. So for instance, let's say a person with a learning disability who might be unable to make a decision about where to live, well, they might be able to make other decisions such as what to eat, what to wear, or what to do each day. So just thinking a little bit about who should be assessing capacity, there is a lot of conversations in my experience and a flurry of kind of discussions about who a decision maker is. But the truth is anyone caring for or supporting a person who may lack capacity could be involved in assessing capacity. And the MCA is designed to empower those in health and social care to do the capacity assessments themselves, rather than relying on expert testing by psychiatrists or psychologists. So good professional training is key. There might be cases that are really complex or involving really major decisions that you do feel you need to get other professionals on board with. So this could be the GP, psychiatrist or psychologist. So people carrying out acts in connection with the care or treatment of a young person aged 16 or 17 who lack capacity to consent will generally have protection from liability as long as a person carrying out the act has taken reasonable steps to establish the young person lacks capacity and reasonably believes that the young person lacks capacity and that the act that they are suggesting is in the young person's best interest and that they follow the act's principles. And with that in mind, we're going to just move over to the next slide and have a little think for a few minutes about those principles. So there are 5 principles within the Mental Capacity Act, and I call this my firm ground. Now, in my practice, I will always seek this out. I'll always seek out my firm ground. Now, I've been working exclusively in a safeguarding role full time, including the Mental Capacity Act, for a significant amount of time. And I consult on cases regularly and support professionals such as yourselves to support legal literacy and practical application of the legislation. Now, more often than not, the cases I hear about are complex with a lot of different elements and considerations. And it's really easy, and I've fallen into this pitfall, but it's easy to get drawn down a particular path or area of thinking, which ultimately means you are missing the basics. So this means my starting point, and I urge you to do the same, is have your 5 ground and start with with those 5 principles. So principle 1 is that presumption of capacity. So every person has the right to make his or her own decisions, and must be assumed to have capacity to do so unless proved otherwise. This means you cannot assume that someone cannot make a decision of themselves just because they have a particular medical condition or disability. And just like I talked about on that title slide, just really thinking about, do we really see 16 and 17-year-olds here as decision makers? Thinking about principle 2, and that's about individuals being supported to make their own decisions, and a person being given all practicable help before anybody treats them as not being able to make their own decisions. So this means you should make every effort to encourage and support people to make their decisions themselves. If lack of capacity is established, it is still important that you involve the person as far as possible in making these decisions. Principle 3 then is unwise decisions. People have the right not to be treated as lacking capacity merely because they make a decision that others deem unwise. We all make unwise decisions every single day. Smoking, drinking, sleeping through their alarm clock. Everyone has their own values, beliefs, and preferences, which may not be the same as those of other people. So it's really important that we respect that. So principle 4 is best interest. So, anything done for or on behalf of a person who lacks mental capacity must be done in their best interests. So in other words, when making a decision on behalf of another person, it must be as close to the decision that the person would have made had they been able to make it. There's best interest checklists, there's lots of resources available, and it must have regard for relevant circumstances, wishes and feelings of the young person, past and present, the view of others consulted, and the identified risks and benefits of available options. The last principle is the less restrictive option. So someone making a decision or acting on behalf of a person who lacks capacity must consider whether it is possible to decide or act in a way that would interfere less with the person's rights and freedoms of action, or whether there is a need to decide to act at all. All interventions should be weighed up in the particular circumstances of the case. So that's your principles. Let's move on to the next slide, please, Leanne. We've covered about who we're talking about. So sorry, let's cover we've covered what we're talking about. Let's talk about who. So within the Mental Capacity Act Code of Practice, children refers to people aged below 16. Young people refers to people aged 16 and 17. And this differs from the Children's Act and the law more generally, where the term child is used to refer to people under the age of 18. The Act does not generally apply to people under the age of 16, but there are 2 exceptions, and that's around the Court of Protection, who can make decisions about a child's property or finances, or appoint a deputy to make those decisions if the child lacks capacity to make such decisions and is likely to still lack capacity to make financial decisions when they reach the age of 18. Offences of ill treatment or willful neglect of a person who lacks capacity can also apply to victims younger than 16. We can move on, please, Leanne. So we're going to think about just some important differences. So where the Mental Capacity Act doesn't apply to young people. So whilst most of the Act applies to young people aged 16 and 17 years old who may lack capacity to make specific decisions, but there are 3 exceptions. So only people aged 18 and over can make a lasting power of attorney.
Some more chili sauce for myself. Is there anything else you want?
That sounds delicious, but can we just have have microphones off, please? Thank you so much. So it doesn't apply to young people that are wanting to make a lasting power of attorney. That's 18 only, 18 and over only, and only people aged 18 and over can make an advanced decision to refuse medical treatment. The Court of Protection may only make a statutory will for a person aged 18 and over. So there are some really important differences that we need to be mindful of when we are working with young people. I'm going to hand you over to my colleague, Leanne, who's going to take the next couple of slides before handing over to Kathy. Thanks, Leanne.
Thanks, Louise. And can I apologise? Clearly, I'm not very good at PowerPoint presenting and multiple screens. So I don't know if you noticed, Louise, but every now and again you lost your presentations.
You're fine. I think you're okay.
I'll never be invited again. So just from moving on from what Louise was talking about, when it comes to getting consent, when it comes to an emergency situation, obviously consent to treatment can be obtained mainly from the young person if they have the capacity to make that. Where there is scope for some parental response, somebody with parental responsibility to make that decision, that's also a possibility. And the third way is for the court to make that decision. So this is when it is an emergency situation and the consent for treatment is required. So when the circumstances are such that the failure to treat the young person would likely lead to their death or some severe permanent injury, then professionals can, of course, provide the emergency treatment. But there is an understanding that it is only what is necessary and in the best interest. And of course, you can always seek legal advice if you are unsure as to whether that is the case. So we've talked a little bit about parental responsibility. Now that can be a little bit of a difficult one to navigate often. So we've popped a little flowchart here in the hope that this will help. So if a child or young person is under 18, what we really need to know is whether there is a legal order in place. So if there isn't a legal order in place, then the sole parental responsibility is with the birth parents. And there are some little caveats to that, which is on the flow chart, but depending on the father having a name on birth certificate, etc. If there is a legal order in place, and the best way to ask that is to whether they have a social worker or if they're subject to any kind of plan. But there is a special guardianship order, and that's shared PR with the special guardian and also the birth parents. However, again, another caveat, the special guardian can override birth parents' decision. If they are under a placement order, that's a placement order is where a child is been placed with prospective adoptive parents while the placement order continues before the adoption actually goes through. The shared PR is actually still with social care, the birth parents, and the prospective adopters. So once the adoptive placement goes through, then that goes into a post-adoptive adoption order, which means that they're no longer looked after, and then the sole PR is with the adoptive parents, because at that point they are then legally the parents of that child. If they're on an interim care order or a full care order, then the shared PR will be with social care. And it's really important to note that when I say social care, we mean somebody like a senior manager or social worker. It doesn't apply to the foster carer or a residential home worker. They are the only people that can sign consent, so it would need to come from somebody from social care. There is a shared PR with the birth parents, so that's obviously another option. The special guardian, if it was an SGO, or if the adoptive parents have gone post-adoption. So like I was saying earlier, once you've got post-adoption, then the adoptive parents have parental responsibility. The reason why a child might be under a care order, even though they've already been through adoption, is often, unfortunately, adoption can break down and adoptive parents can struggle, and therefore there is occasions where they come back into care. but the adoptive parents will still have some parental responsibility in those instances. And it's important to note that social care can overwrite if they don't feel that the decision is the correct one when it comes to the birth parents or adoptive parents or a special guardianship. Ultimately, they will have the final say if need be. But often, obviously, best practice is for everyone to agree on the decision going forward, including the child or young person themselves, of course. The final one is a Section 20. Now, this is known as a voluntary placement, and that means that the birth parents continue to have parental responsibility, and so they are the only ones that can use that parental responsibility, and that is the case if they are a special guardian or if they are adoptive parents, and it's post-adoption. So I think I'm handing over to Kathy now.
Thank you. That's excellent. Just to say, really, one of the main things and what really does make all of us really passionate, people who are on this call, but also the team around us, Leanne and Louise, myself, is this is all about individual autonomy. The Mental Capacity Act is all about that. So some really quick, helpful tips for you. In the middle of A&E, in the middle of anything. Do you mean wherever you are in your workplace? Under what legal framework am I able to do what I'm thinking of doing? This should be a question that's at the foremost of your minds, okay? Because there must be a basis in law. So whether it's emergency procedures, whether it's parental responsibility, whether or not it's the MCA or the Mental Health Act, what is your legal framework you're using? And when we think about these acts and legislations, often there's a little bit of a pitfall that we fall into because we haven't really thought about consent. Consent is the main part. Consent is part of the Montgomery ruling. Its consent requires that information to be exchanged to be able to demonstrate informed consent. It's not just sign here or just because somebody passively complies. It does not protect you in law. You need to record consent and you need to be thinking about consent if you are truly wedded to human rights and individual autonomy. So there's my real push. Do you know what I mean? And next slide, let's move us on. So the main frameworks that apply to the young people that are here for us. There are currently no specific rules for deciding when to use either the Children's Act, Mental Capacity Act, or when to go to the High Court. So it makes our job really difficult, isn't it? So if anyone's sitting there thinking like, I just don't get it, sometimes it feels really hard. Well, that means you probably do get it because you're stopping and you're questioning, and that's exactly what you need to do. It's never just very clear one or the other, and it requires MDT and it requires some discussion. And it is important, you will hear this message from all three of us today, is that you as a professional, you as a leader can seek legal advice and you can ask for this and ask for it within your organisation. But there are some frameworks, so you will have, as Louise has referred to, emergency treatment, as we've just spoken to as well with both Leanne and Louise, consent from the child or young person themselves. Barn door obvious. If you can get it, you should be looking at that. Do you know what I mean? That's it. It's there, and this is where we empower young people. This is where our transition work comes in, guys. Children's Act, really important. And as I said, for that parental consent and parental responsibility. And as that scope, diminishes the older they get. So anyone with children, anyone here who knows children, relates to children, works with them, will know, what our parental scope is at 5 is very different to what it is at 14 and 15. We might not like it, but it is just the facts and it is there. Mental Capacity Act is another one, and as I've said, the Mental Health Act. Court orders and the High Court inherent jurisdiction. We're not going to go into all of these things today because it is a session where we're kind of giving you some highlights and then asking if you've got any questions and things that we can help with. But it's really important that we understand that there is a legal process to this and certain ones will need to be going to the court in order to get that. And Court of Justice, in London has been set up to hear deprivation of liberty, small s. So they're normally within a community setting. Or within a secure setting, will go to the High Court judges from the family division. So that was set up. And I think, previously in 2022, there was over 1,000 cases going. So it is a big issue. We know it's a big issue. Next slide, please. So when do I move to an assessment for a young person? Well, when I'm talking to people about those things, and when it was really helpful for me, is I used to get a little bit stuck on the presumption of capacity. Do you know what I mean? And going like, yeah, but you've got to assume capacity, and you don't do to people, you know, it's their decision, it's entirely up to them. And I learned probably, you know, more so in the last 6 to 7 years, if I was honest, to be sitting there thinking like, I also can't hide behind the presumption of capacity. If I feel that there is a concern, if something is telling me, now whether that's pattern recognition, gut feeling, whether that's something I am seeing, whether that's executive capacity, whatever that is that I'm seeing that's making me question, then it is a time when you should be considering and questioning, do I need a capacity assessment here? And just so we're really clear, I have done and undertaken capacity assessments where the outcome has been that the person has capacity. So if there's any myth that people think, well, they're always supposed to turn out that person lacks capacity, think again. Do you mean it is a way of recording your decision and your thought process through that? An assessment should take place whether there is a concern that an individual might lack the capacity to make that proposed decision. You need to also consider recording why you don't feel an assessment is required in some circumstances. The proposed decision could be to agree to a health examination. So people say to me, when does this come about? A review, care arrangements is about their care and treatment. Young people are involved in health services all the time. So this is something that does come up. It could be their wound care due to some self-harm. It could be equipment adaptations. It could be their initial health screening, social care assessments, all of those areas. And you would undertake a mental capacity assessment of that particular specific decision. Thank you. Next slide. So decisions that would deprive a young person of their liberty, and what we're talking about there when we're talking about the right to liberty is your Article 5 rights. So these things are all founded in the Human Rights Act. So it is possible for you to make a decision that is likely to result in a young person being deprived of their liberty. And often we think, well, that's the best thing for us to do, and that's the right thing for us to do. But it's what you need to do is consider and just think about, what am I doing? Am I depriving that person of their liberty? You must not do so unless you are satisfied that that is the least restrictive option. So that was in the hand that, you know, Louise showed you in the beginning with the Mental Capacity Act. But also, to deprive someone of their liberty, they have to lack capacity for that decision. Do you know what I mean? So you will never have someone saying they're deprived of their liberty, but they have capacity. It means you haven't understood it. You haven't got it right. Do you know what I mean? Because you have to lack capacity for that decision in order to be able to look towards a deprivation of liberty. The proposed deprivation of liberty will need to be authorised by the Court of Protection when we're talking about young people in this part. So you will have, and some of you will have deprivation of liberties where it's adults, do you mean, and they're in a care home or in a hospital, and that's through a supervisory body and a managing authority. That's different. That's the deprivation of liberty, and that's done within that framework. But what we're talking about is sometimes community deprivation of liberty, and for these young people, and that's why it has to be looked at and authorised. And you can understand that because we're talking about removing their right to freedom, to liberty, to movement. And we need to make sure that that has a robust framework around it to ensure that we're doing the right thing. And in most cases, you know, in my experience, we are. Do you know what I mean? It's just whether we have put that down and recorded it appropriately. And it stops us and prevents us from having a system that would prevent people from having their liberty, and it was just made by one person or two people and that decision's done and we don't check. We've got lots of those cases, you know, particularly adult cases, the Neary case, different things like that, where that has happened and families' views and individuals' views have been overrun. Next slide, please. So a deprivation of liberty, some of you may already be aware of this, is about confinement and the, you know, acid test, which came from the Cheshire West case a long time ago. So a person is seen to be deprived of their liberty if three conditions are met. One of them is the objective component, i.e. the person is confined to a particular place for a non-negligible length of time. Then you've got your subjective component, you know, the lack of valid consent. Do you know what I mean? So that they haven't consented to that. So hopefully that meets with the two things that I said earlier in the previous slide. And the third being that it's an attribution of the responsibility to the state. Now that when we look at the word responsibility to the state, it means, do we know about it? And if we know about it, then it is our responsibility. And that's the easiest way for me to explain that. So the acid test is the lacks the capacity to consent to their care and treatment arrangements. Could be where they're going to reside. Do you know what I mean? Could be where they're accommodated, could be particular treatment they are receiving. And that they are under continuous supervision and control. And that equates to usual levels of observations. So it doesn't mean that you're walking around with them constantly. Do you know what I mean? You know, if you know somebody's whereabouts all the time, then you could equate that to continuous supervision and control, because they're not free to leave and you know where they are all the time. So it doesn't necessarily mean you got one-to-one observations going on, or that you're in the same room as somebody. Do you know what I mean? You need to be thinking about that continuous supervision and control and what that really means. And think about that in relation to, you know, liberty and freedom and what you would be able to have. And the third one on the acid test is they are not free to leave permanently. So it doesn't matter whether or not they can leave. And I think that's really important. One of the areas that, you know, you could have somebody with, you know, who is, you know, confined to their bed, do you know what I mean? And they are not able to get up, or a spinal injury or something like that. And someone said, well, they wouldn't leave. They can't leave. That doesn't mean they don't have the same rights as all of us. We all have the same rights under the legislation. So it would be saying, like, but if they tried to leave, do you know what I mean, what would happen? And if you're going to say, well, I'm going to escort them back, I'm going to bring them back, I'm going to bring them back in, it's not going to be, they can't just leave and go, then you are looking at that acid test being met for all three. So human rights are the same for everyone, as I've said there, regardless of an illness or disability. And, you know, there's a little quote here that Lady Hale said, if it would be to deprivation of my liberty to be obliged to live in a particular place, subject to constant monitoring and control, only allowed out with close supervision, and unable to move away without permission, even if such an opportunity became available, then it must be a deprivation of the liberty of a disabled person. So whilst we can understand why those things may well be done, because people may have, you know, concerns that somebody will, you know, walk into traffic or different areas, and thinking about the risk and the necessity and the proportionality, a gilded cage is still a cage. So it's not about our intent or why we're doing that. If we are depriving somebody of their liberty, we are depriving them of their liberty, and we need to make sure that we have got the right legal orders and the right frameworks in place for that. Thank you. Let's move us through. So relevant case law that was really quite, you know, a few years ago now, but, you know, for 16 and 17-year-olds. And I like this slide. And, you know, I'm not going to go too much into the case, but it was a young man with ADHD, do you mean Tourette's and Asperger's, and a mild learning disability, you know, and it was in the Supreme Courts in the matter of Child D. And it makes it very clear, you know, that Supreme Court handed down the long-awaited ruling in relation to whether parental responsibility for our 16 and 17-year-olds can or cannot be given, give consent regarding a deprivation of their liberty, as in the Cheshire West, you know, and in short, parents can't. So the answer is they can't. So 16 and 17-year-olds that you want to deprive of their liberty, you cannot do it as a parent. You have to have a legal order. It is not within parental scope. It is under the Mental Capacity Act, and it would need to be within a court arena. So presently, the deprivation of liberty safeguards, the big S, do you know what I mean, you know, which only applies to those over 18. So sometimes people can get confused and see that. That deprivation of liberty safeguards there is for the people over 18, and it's leaving what we'd call deprivation of liberty, and sometimes people put it as a small s, or community doles deprivation of liberties, as the only route to authorise this deprivation for a young person. And that would currently be an application to court of protection or the High Courts. And I would say that in most cases you will want your legal teams involved, or at least to have sought some legal team advice. And you can challenge and discuss with your partner agencies and MDTs around that. So what do we really know about the reality and acknowledging the gap in provision for children and young people and secure accommodation? I know this is really real for all of you out there. Do you know what I mean? And, you know, I've worked across, you know, sectors and done some work previously with hospital settings and our A&E departments. And therefore, you know, we are seeing this in reality, and it is a national, regional issue, and an issue that has been raised, by, Sir Andrew McFarlane, do you mean, to the previous government, do you mean, about concerns about the lack of secure accommodation and provision. And, once again, he put on here about the primary purpose is for courts to draw public attention to the very substantial deficit that exists. So what I would say to you is, yes, it is our reality that we are still working within this, but to be mindful that people are doing it. And it's not one service over another. This is not social care's issue. This is a health, social care and a human rights issue. This is a big issue. So we've got the judgment there if anyone wanted to have a look. Next slide, please, Leanne. So how does DOLS relate to the experiences that you might have now in looked after children and young people's settings? Section 20, this does not authorise a deprivation of liberty. I'm not going to say any more than that. Do you mean, so anyone who's sitting there or somebody's in a MDT or the social workers go, no, it's fine, we're under Section 20, that does deprive them of their liberty. It does not. Okay, so a Section 25 for over 16s and the use of accommodation for restricting liberty does. Do you know what I mean? And that, but once again, you'll be mindful. It should have the MCA evidence in practice and all applications. So if in doubt, talk to your social work colleagues and look at the care plans and the details. What does it say about the restrictions? Are they necessary? Are they proportionate? That is your role to do as an MDT and to kind of discuss and explore. And we should see those. They'll also be within these units because they're regulated units, for example, absconding, significant harm to themselves or others. All of those risk factors and mitigations of risk will be put in there. The reality, as I know, and I don't wish to, press too much on that, but there is not enough secure units to meet the needs of our, young people. So respite care, think about it. How are you supporting children and young people? And the consideration of practical steps, have you looked at that and thought, is there a deprivation of liberty required? When the case with Child D come in, social care had to look at a lot of placements and were they depriving people of their liberty, that they couldn't rely on parental consent anymore, and what was happening and what did need to happen in respite care. One of the things I've really learned and found brilliant is the SALT referrals and, getting communication and support. They can really help as well with the practical steps, that Louise talked about earlier as part of the Mental Capacity Act, in communication and effective communication, more importantly. Personalisation, care planning, writing things on the care plan, being clear what that is and the risks and the necessary and proportionate all help to give good evidence. Thank you. Next slide. So some myth busting, there is no legal basis for next of kin. We often have this and then somebody in the chat goes, oh, there is, and that, and we had a good look at this, do you mean, and a way through, and NHS England did a lot of work around this and promoting this. If your loved one is unable to provide consent for themselves, being a next of kin does not give you the legal right to consent on their behalf. You would need, as Louise referred to earlier, a lasting power of attorney, a deputyship, something like that. Health and social care colleagues should always consult with the people closest to the person who lacks capacity, because they might be somebody who understands their wishes and feelings and helps them decide. The Mental Capacity Act is full of that. It is key about that. So this is not to exclude family members or their views. They are equally important, and you wouldn't be applying the legislation if you ignored any of that view. However, the person identified as next of kin should not be asked to sign consent forms. We saw this in different settings. We've saw this in supported living, do you mean in tenancy agreements, all of those kind of things. There is no legal basis for doing so. This is a mistake. It's often made in any hospitals, nursing and residential types of accommodation, as I've said. Sorry, sometimes you repeat things, do you know what I mean? And then it's in your slide there, isn't it? And, end of life plans, other treatments to provide consent, it is not legally valid. Having parental responsibility is not the same as being next of kin. Thank you. Let's move on to our next. Oh, it's over to you, isn't it? So, yeah, back over to you. Yeah, thank you.
Thanks, Kathy. So, yeah, we're just going to talk a little bit around about the differences between children and young people when it comes to making decisions. There's a general understanding that anybody under the age of 13 it would be really rare to be asking a child to make a decision or give consent to treatment. There is no lower age limit for a Gillick competence. However, it's unusual, and therefore we would probably ask you to seek advice if the child was under 13. The child who's between 13 and 15, however, the big difference between our under 16-year-olds and our over 16-year-olds is that we are looking for a competency. We're looking to see if the child is competent to make the decision, whereas 16 plus, we're looking at capacity. So it is a slightly different way of looking at things. So we are looking, using the Gillick competency, we're trying to determine if this child can consent to treatment. So if we have established that they are Gillick competent and they are still refusing treatment, then the question needs to be, is the treatment in the best interests? Is there a risk to them of permanent damage or death? And if there is, clinicians can overrule, as long as there is evidence that it's in the best interest of the child. However, we would say to seek legal advice at this point. If a child is not Gillick competent, then a person with parental responsibility can consent to treatment. And we talked about parental responsibility earlier and who holds it. The consent can be given on their behalf. However, if the treatment is going to result in a deprivation of liberty, like Kathy's just said, we would need to get legal advice on how we'd be able to do that. So if the person with PR doesn't consent to treatment, again, clinicians believe that the treatment is needed because of the risks, then again, you would be seeking legal advice for those children. And then for those that are over 16, we are now looking at capacity because it does fall under the Mental Capacity Act. So they are presumed in law, like the adults, just as Kathy said, have the capacity to consent to the medical treatment. However, if you think that there is any reason to doubt the capacity, then you would go along the same MCA guidance, which is to complete a capacity assessment. If they lack capacity, then if they are 16 to 17, then person with a parental responsibility can possibly can consent to treatment, and a best interest decision can be made also for treatment. However, if that treatment involves a deprivation of liberty, it still requires practitioners to seek legal advice. If they lack capacity and the clinicians believe that treatment is in their best interest, again, they would need to seek legal advice. However, if they do have capacity, then again, clinicians still believe that the treatment is in their best interests. All arrows point to seek legal advice. So hopefully that's just a flow chart to sort of make things a little bit more straightforward. I think that's the end of our presentation. We've got some useful links there, but we'll open up for questions.
Yeah, thank you. We'll just stop. We'll stop the recording, if that's okay, Kathy. Look, it's a really tricky session, and you know, the Mental Capacity Act